Hello, everyone, and welcome back to Beyond the Evidence, the podcast where we dive deep into true crime cases, uncovering the facts and exploring the unanswered questions that keep us coming back for more. I'm your host, Marv, and I want to thank you for joining me today. If you haven't already, please subscribe to my YouTube channel and hit the notification bell so you never miss an update. And if you'd like to support the channel, you can find links to my PayPal and Cash App in the description. Now, let's get into today's topic.
Breaking all the patterns, facts and theories, clues and controversy. Join the journey, uncovering the mystery. This is Beyond the Evidence, where justice prevails, with Marv leading the way. Truth never fails. Now get ready for this live stream. Super chat, highlight your message. Don't fall victim to the irrelevance. Hit that like, share, subscribe to Marv's Beyond the Evidence.
Hello, everybody. How's it going? Oh, funny story. I gotta tell you, y'all know that I've been having trouble reading. I have bifocals. So I went to the eye doctor the other day, and she's looking at my glasses, and she's like, "Are you having trouble reading?" I'm like, "Yeah, I am. I have to take my glasses off most of the time to read anything, or I have to blow it up." She goes, "Yeah." She's like, "I can understand why that is." She's like, "Your bifocals pretty much don't exist in your glasses." She said, "They're so far down that even if you put them on the tip of your nose, you can't read through them." I'm like, "Yeah." She's like, "We're going to fix that." I'm like, "Thank God." Needless to say, this is a new eye doctor that I've gone to. And I can't wait to get my new glasses. Cannot wait. So we're here to talk about the defense's new motion. And at this point, I'm pretty sure that Judge Gull has just given up. I think she gave up a long time ago, like a year and a half ago, actually. I'm pretty sure. She just didn't want to deal with this case properly. She didn't have hearings like she should have. She denies everything. She just wants it to move on. So, should Baldwin keep filing these motions when he knows she's not going to do anything? Because you know darn well this one's going to get denied. She just wants it to go to the Supreme Court and let them deal with it. She's not going to waste any more time on this case. I can tell you that. And it's sad because that's not how the law in a court should work. Yeah, so it's going to be the same nasty judge. I don't know. Holly, thank you so much for becoming a member. I think we're going to have our first members live. I'm pretty sure, actually positive. We're going to have it this weekend. I'm going to do a test with Andrea to make sure I can see all your comments. And the topic is going to be Casey Anthony. There are a lot of things that I have to say about what's happening, and no better place than be able to let go than in a members live. Hey, Mr. Scott, how are you? Hey, Andrea, she says, I'm here. Thank you for coming. I know you haven't been feeling good. So thank you so much. Okay, so I'm going to blow up my document so I can read it. Let's go through what the defense wants done now. Share my screen. All righty. Now, this was filed on March 4th, a couple days ago. Thank you all for being patient with me. Living out in the rural area, when we get that kind of weather that we got the night before and yesterday, the internet does not work very well here. And with all the rain that we got before the snow and then it freezing, it's absolutely crazy what happens to our internet. So, mothers of masters, oh, I wish that woman would shut up. Oh, I wish a lot more would happen to her, but we're going to talk about that. Look, I'm thinking I got to double check my schedule for this weekend and make sure that there's no special activities going on for my son. But it looks like Saturday evening is going to be the members only live once I check that schedule. That is my first preference. So if you want to hear what I have to say about Casey Anthony, join the membership. Now, getting back to Delphi once again. Richard Allen's verified reply memorandum to State of Indiana response to preserve and produce and request for sanctions. So they're up to, let's see, their third request. I think this is third request to preserve and produce. The first two were denied, and now they're requesting sanctions. Which again, I'm telling you, this will be denied, but let's see what they have to say. Comes now Richard Allen by counsel and files this reply to the State of Indiana's February 28, 2025 response to Allen's motion to preserve and produce, and also requests sanctions for the state's violation of Carroll County local rules concerning exculpatory evidence. In support of said motion, Allen states the following. The prosecution's response brief provided proof that the state of Indiana failed to turn exculpatory evidence over to the defense. Now, my question is, who determines if it's exculpatory evidence? So I'm typing this in to ChatGPT, okay? And I just put in Indiana, who determines if evidence is exculpatory. It says in Indiana, the determination of whether evidence is exculpatory, meaning it is favorable to the defense and could possibly impact the outcome of a case, is primarily made by the prosecutor. Under the Brady versus Maryland ruling, prosecutors are legally required to disclose exculpatory evidence to the defense. However, If there is a dispute over whether certain evidence is truly exculpatory, a judge may ultimately decide after reviewing the evidence. Defense attorneys can also file motions requesting disclosure of evidence they believe is exculpatory. And if the prosecution fails to provide it, the court can intervene. If exculpatory evidence is wrongfully withheld, it can lead to appeals, overturned convictions, or even prosecutorial misconduct claims. Now, this is the fastest way that I know of to research nowadays. I use 3 AI systems. I use ChatGPT, I use Copilot, and now I'm using Gemini from Apple. So, exculpatory evidence is any evidence that is favorable to the defendant in a criminal case and may help prove their innocence or reduce the culpability. This can include witness statements that contradict the prosecution's case, surveillance footage, or photos disproving allegations, forensic evidence such as DNA that excludes the defendant, alibi evidence showing the defendant was elsewhere, statements from the victim that cast doubt on guilt, records or documents that support the defense's argument. So now we know what exculpatory evidence is. And in this case, we're talking about the letters from Ricci Davis. Okay. In his response, the prosecutor glosses over the fact that he was in possession of letters that he failed to turn over to the defense before trial, even though in a February 13, 2025 email, he denied possessing such letters. McClellan also has no explanation as to why a letter from Davis from October 15, 2024 is missing and cannot be found. Instead, the prosecution spends the majority of his response denigrating defense counsel. Prosecutor McClellan is not the arbiter of exculpatory evidence or whether he has an obligation to turn it over. Now, wait a minute. He just said that he's not the arbiter of exculpatory evidence, but we just read in Copilot that the prosecutor determines whether it's exculpatory or not. The law is the arbiter. Exculpatory evidence is defined as evidence tending to establish a criminal defendant's innocence. State versus direct. Carroll County Local Rule 18b2 also requires McClellan to turn over exculpatory evidence. Based upon his February 28, 2025 filing, we now know that the state of Indiana has certain letters in its possession in October 2024, but failed to turn those letters over to the defense until February 28, 2025. The prosecution only produced those letters after the defense sought those letters, being forced to file a motion to produce those letters after the prosecution failed to admit being in possession of those letters. Okay. One of the things that you have to remember in this case is that there was a motion of limine. Okay. That motion of limine said no third party, no Ron Logan, no Keegan Klein, and other stuff. So it was decided by the judge that this information was not pertinent to Richard Allen's trial. So why would the prosecutor think some letters from Ricci Davis were exculpatory and turn them over to the defense? They wouldn't. They didn't. It's not until the defense got hold of this information and wanted it. This behavior of the state is consistent with a pattern of behavior that has greatly impacted the defense and Richard Allen's constitutional rights throughout the entirety of this case, as will be recounted later in the memorandum. A pattern of withholding exculpatory evidence may lead to a reversal and new trial. Pewitt versus State. This case illustrates what happens when the state engages in a pattern of withholding exculpatory and material evidence from a defendant prior to trial. In Pruitt, the Court of Appeals reversed the conviction when, soon after the conviction, the defense counsel learned of evidence that the prosecutor failed to turn over to the defense prior to trial. So, in my previous live, I said I wanted two things to happen. Okay? I want special investigators put on this case. I don't know who we contact to have that done or request that it be done, but I want independent people to go over all of the evidence, everything that the prosecution received, and to determine, so you're going to need a special prosecutor for this also, and to determine whether it's exculpatory or not and should have been turned over to the defense. Okay. 2, I want this to go to the appeals court. I want the appeals court to tell us what Judge Gull did right and what she did wrong. Okay. That's who's going to hold her accountable. And somebody needs to, in my opinion. Defense theory. At Allen's trial, the defense indicated that the evidence supported that on February 13, 2017, the victims were abducted. What evidence are they talking about? Because I didn't see any evidence presented in that trial that supported that. That is a delusion of theirs. They were taken somewhere else, perhaps in a vehicle, and then during the early morning hours of February 14th, 2017, after the search parties had left the area, were ultimately transported to the location where they were found on February 14, 2017. Further, the defense's theory was that evidence strongly supported that multiple people were involved in the abduction. I love how they keep saying their evidence. I watched that trial. I sat in that courtroom. That defense did not provide any evidence, concrete evidence of any of this. None. They made assumptions and assumed, but they did not actually present enough evidence to make anyone think any of this was true. The defense theories were detailed in the defense's opening statement and throughout trial or in offer to prove from August 1st, 2024. Yeah, exactly. That's all this has been all this time, is defense theories. Not proof, not evidence, theories. State's theory. The state's theory was that in some order the following events occurred. The killer, acting alone, after running or briskly walking across a bridge to catch up to the girls, since he was not seen in the 207 photograph anywhere on the bridge, was seen on video, walking casually and not panting like a 45-year-old man who had run across the bridge. Then abducted 2 victims, slid down a steep hill with those victims, then in panic, after observing a van, corralled those victims across an active creek while holding a gun, and then both victims somehow were undressed, but the younger victim was later redressed in the pants, bra, and sweatshirt of the older victim, and the lone panic killer murdered 1 victim and then murdered the other victim without anyone hearing any screams, in spite of sound traveling very well throughout that area, all the way to the bridge. Now, let's talk about that sound travel. I've been out there screaming my head off in the area across the creek, not at the actual crime scene, but across the creek, screaming my head off and contacting with the people on the bridge. Can you hear me? I can barely hear you, yes, but I can't make out what you're saying. But yet they say in spite of sound traveling very well throughout that area, all the way to the bridge. My question is, have these idiots even been out to this area and walked all the way around? Have they? That's my question. Then the lone panic killer moved the older victim from one area to another area next to a tree without any drag marks. I'm going to find the video that I took the last time I was at the true crime scene, and I'm going to show you how small this area was. And I'm going to do that on a members only live because I'm not going to do that publicly so that Becky and other family members have to see it. They've seen it already. So that will be another members only coming up. Because he's saying carried her from one place to another. It's a matter of steps. It's not like you're going hundreds of steps. It's a small area. All that activity, according to the state's theory, occurred in 19-minute time frame between 2:13 and 2:32 p.m. when the older victim's phone stopped moving, having been placed under a shoe under the younger victim's body. Okay. After the murders, the state's theory was that this panic killer then took time to place sticks on top of the victims' bodies in particular patterns as depicted in photos submitted at trial. And then, in spite of his panic, hung around the crime scene for over an hour before exiting the crime scene northward near a cemetery before this panic killer chose to walk westbound towards his vehicle on 300 North in a bloody outfit, knowing that he would be in full view of any vehicles traveling that road after having killed the victims an hour and a half earlier. The state's theory was not that the multiple women were involved in the crimes, but one man alone committed all these acts and did so on the afternoon of February 13, 2017. Ricci Davis letters provided exculpatory information that supports the defense's theory and negates the state's theory, and also provides other information that the defense could have utilized for trial or to support its request for third-party suspect evidence to be admitted into evidence. In Davis's letter that the state of India did not turn over to the defense before or during trial, Ricci Davis stated that Keegan Kline, a key suspect in the case, confessed to the murders. Well, we all know how legitimate and truthfulness Keegan Kline is because he lies all the time. A key suspect confessing to the murders is exculpatory evidence as it tends to establish a criminal defendant's innocence. At a minimum, Carroll County local rule required McClellan to immediately turn those letters over to the defense, even if he, McClellan, believed that the letters did not need to be turned over because of Davis's claim that Richard Allen was involved in the crimes alongside Kline and Logan. When police or prosecutors conceal significant exculpatory or impeaching material in the state's possession, it is ordinarily incumbent on the state to set the record straight. So, in Cliff Note number 1, Carroll County local rule. Additionally, McClellan claimed that he was not obligated to turn over the letters because of Davis's claim that Richard Allen was involved is not a judgment call for McClellan to make. Richard Allen was at home on the evening of February 13, 2017, and the morning of February 14, 2017, according to Davis's letters. Kline indicated that Allen was with them during that night and morning assisting in the murders. It is McClellan's obligation to turn over exculpatory evidence to the defense and let the defense determine how to proceed. So the question is not whether the defendant would more likely than not have received a different verdict with the evidence. Yes, that is the exact thing that's going on here. That is what the Supreme Court is going to look at. Would this evidence have made the verdict different? But rather, in its absence, he received a fair trial understood as a verdict worthy of confidence. The jury in Richard Allen's case was out for nearly 4 days, a very lengthy deliberation period. In whose mind is that? Because nowadays, you get 1 hour for every day of trial. The jury deliberated, I believe, 19 hours, which was maybe an hour more than the calculation for 1 hour for every day. All right. If it could be shown that they knew each other, that would be a significant fact for the court to consider when determining matters of the third-party suspect defense, and also for a jury to consider. I agree with that. The fact that Kline also implicated Allen would not have been of a concern of the defense, as the defense knows that Allen had no linkage to either Kline or Logan, and also because the evidence supported that Allen was with his wife the night of February 13th and the morning of February 14th, when Kline is claiming Allen was with Logan and Kline committing the crimes. So wouldn't that right there stop you and make you think that this is a lie? You guys tell me what you think on that. Had the defense known of the information contained in the Ricci Davis letters, it would have renewed its motion for third-party suspect defense regarding Kline and Logan and would have further investigated these claims. Perhaps the defense would have sought a continuance to investigate the ties between Logan and Kline. the defense would have argued that Keegan Kline knew details of the crime that no one else knew, and furthermore, that he, Kline, was protecting an unknown third party by claiming that Allen was the third party after Allen's arrest. The defense could do none of that, as well as any other number of legal, strategic, procedural maneuvering of the defense was in the dark about the contents in the letters while the prosecution was fully aware of that information. The details that Kline provided to Davis add to the exculpatory value of those letters. On page 4 of one of those letters, Davis claims that Kline detailed that the girls' bodies were moved 3 times and that they were not killed where they were found, and furthermore, that their bodies were staged. These are facts consistent with the defense theory and facts that oppose the state's theory. Furthermore, in the letter, Davis claims that Keegan Kline detailed how the killers got nervous and left town in their own cars, with at least one of them going to Lafayette to get rid of evidence. It is known that Ron Logan went to Lafayette at some point in time to purchase exotic fish, after having asked a relative to assist him in creating an alibi. These are all facts that Ricci Davis would not know, but that the killer would know. All of these facts tend to establish Richard Allen's innocence. In the second letter, Davis claims that back in 2018, he, Davis, reported that the victims' throats were sliced. This is something that only the killer would know, especially when the details of the murders were not known at that time. He also stated that he reported that the girls were hidden in a barn and also driven around at some point in time. That is consistent with the defense's theory that the girls were driven in a car at some point and held somewhere until the search parties had left the area, and inconsistent with the prosecution theory. On page 3 of that letter, Ricci recorded that Keegan Kline told him that the scene was staged and furthermore mentioned that the girls could not be moved because the search parties were everywhere throughout the night at the time, meaning that the girls were moved to the place they were found only after the search party left the scene. Well, here's a big problem. The official search party with the police left the scene, but there were still individuals out there all night and all that next morning until the official police search parties came back. And it wasn't just a few people. It was quite a few of the community out there looking for the girls. This is just the defense claim, thereby supporting the defense theory and negating the state's theory. In his February 12, 2025 interview at Newcastle Prison, Ricci Davis provided further details that he, Davis, believed that he also provided to the prosecution concerning details that Keegan Kline stated to Davis. In that interview, for example, Ricci Davis claimed that Keegan Kline stated that the girls were handcuffed to each other. After the meeting, defense counsel Ajay Baldwin and investigator Matt Hoffman viewed the crime scene and autopsy photos to determine whether there were any indicators on the victim's wrist that would support this new information that the victims were handcuffed to one another. The admittedly non-expert eyeballs of the attorneys and investigators observed straight lines on the left hand of the wrists of both girls, which, if true, could indicate that one victim walked immediately behind the other with each of their left hands handcuffed to each other, so that they could not easily run away. If the defense had received those letters, it could have learned these facts from Davis during a deposition. If they weren't contained in the letters, and then had experts view the same photos to determine whether the photos were indicative of the girls being handcuffed. Had the defense known of Keegan Kline's statement to Ricci Davis, it could have brought both Keegan Kline and Ricci Davis in for a deposition after hours or during the weekend while the trial was occurring. These depositions could have revealed additional information, including whether at some point in time Keegan Kline finally admitted that Richard Allen had nothing to do with the crimes, as Ricci Davis stated to counsel during a jail interview on February 12, 2025, and also to show that Keegan Kline's claim about the activities of the third person involved with him, Kline and Logan, was inconsistent with Richard Allen's whereabouts the night of February 13th and morning of February 14th. The defense likely would have called upon Kathy Allen to show that Richard Allen was at home during that time frame and not with Logan and Keegan Kline. So my question is this. The defense team put in a transfer during the trial to bring Keegan Kline and Ricci Davis in to testify. Why didn't they? Why did that transfer never take place? And why were they never put on the witness stand? Because they had the opportunity to do it, but they chose not to. Why? Let's see here. There's going to be more wrongs than rights with her? Well, we'll see. I agree. I think she did a lot of things wrong in this case, but we'll see what the appeals court has to say. The judge wouldn't let them say or do anything they need to do. Love and prayers, R.A. Linda, that's your opinion. We'll find out. Yeah, I am angry about this case. It is so messed up. And after 8 years, those families deserve some peace. This is a witch hunt. Logan wouldn't have crossed the bridge to get to his property. He wasn't bridge guy. Richard Allen is bridge guy, and he's the killer. Lynette says BS. I say BS. I believe the autopsy would show indications if the girls were moved after death. Right. And in the testimony, it said that Abby was killed in a supine position, which means laying down, that she never moved. However, when it came to Libby and the pools of blood, they knew that she had been moved. And by the blood smear on her body, because she had been drugged through those pools of blood. It is a criminal trying to get his day in the sun. Richard Allen confessed over and over. His bullet matched his gun marks. If a new trial is granted, the results will be the same. Guilty. I also believe the girl's wrist would have shown some type of marks if handcuffed. I agree. Because Gull denied the third-party motion mid-trial, she should have had a hearing. She should have had a hearing on the Franks. She should have had a hearing on all of their motions, in my opinion. This is the first I've heard of handcuffs. Yep. Why didn't Richard Allen's wife testify? Because she didn't want to commit perjury. Well, we don't know if that's true. Gull denied their third attempt for third-party culprit right before the state rested its case during the trial. Yes, she did. She told them they had no nexus. Now let me just say this. As I said, during that trial, I was waiting for the defense team to bring it. Right? Bring something. All they brought was theories. They didn't actually have any physical evidence. None whatsoever. Because if they had, they would have brought it in. And it would have been the smoking gun on the defensive side. It would have been the big aha. There was none of that. The defense had trouble with their cross-examination of witnesses. Why is that? I still don't understand that. It's not like these 3 attorneys haven't been doing this a long time. Why did, in my opinion, why did they do things so wrong in this case? Yeah, you're right. No, that's not true, because Ricci said that he wanted to only communicate with the prosecutor because of Baldwin and his actions. He didn't want to communicate with Baldwin anymore. Maybe. What do you think a nexus is in the court of law? Do we need to go there? When a judge says that a nexus has not been provided, what do they mean by a nexus? When a judge says that a nexus has not been provided, they mean that there is no clear connection or link between 2 things that need to be legally related in the case. For example, in evidence suppression, a judge might rule that there is no nexus between the alleged illegal police conduct and the evidence being challenged, meaning the defense has not shown how the evidence was obtained unlawfully. In probable cause hearings, a judge may say there is no nexus between a suspect and a crime, meaning the prosecution has not sufficiently linked the defendant to the alleged offense. In civil cases, a judge might find no nexus between a plaintiff's injury and the defendant's actions, meaning there's no clear causal relationship. Essentially, a nexus refers to a necessary logical or legal connection, and without it, the argument or claim may not hold up in court. What nexus was missing in the Delphi murders case? In the Delphi murders case, one of the key legal issues has been the lack of a clear nexus connection between suspect Richard Allen and the actual crime scene, or the murders of Abigail Williams and Liberty German. So, connection between Richard Allen and the murders. Prosecutors argue Allen was on the Monon High Bridge trail that day and admitted to being there. However, the defense argues that no direct forensic evidence, DNA, fingerprints, places him at the crime scene when the murders occurred. The unspent bullet theory. Prosecutors claim a .40 caliber unspent bullet found near the bodies was cycled through a gun owned by Allen. The defense has challenged this as weak evidence, arguing no clear forensic link proves Allen was the one who fired or placed the bullet there. Lack of witnesses or surveillance linking Allen to the crime. There are no eyewitnesses who saw Allen committing the crime. No video or DNA evidence ties him directly to the murders. Weak nexus in the Odinism theory. The defense has argued that law enforcement ignored alternative suspects and a potential realistic killing theory tied to Odinism. They claim that evidence supporting this theory was never fully investigated by police. If the prosecution cannot establish a strong nexus between Allen and the crime scene beyond reasonable doubt, the case against him weakens. The defense is trying to argue that law enforcement lacked a proper nexus, before arresting and charging him. This is the key issue that could affect whether evidence is admissible and whether the prosecution can prove its case at trial. How does the nexus reflect on the defense's theories, and why was third party involvement not allowed? The lack of a strong nexus between Richard Allen and the actual crime scene is central to the defense's argument that he is being wrongly accused and that investigators ignored other potential suspects. The defense has presented alternative theories, particularly suggesting a third-party involvement, specifically a theory involving a ritualistic killing tied to Odinism, but they have faced legal challenges in presenting their argument in court. The Odinism theory alleged ritualistic killing by others. The defense has argued that other individuals, possibly Odinist, were responsible for the murders of Liberty German and Abigail Williams. They claim that the symbols and markings found on the crime scene suggest a ritualistic killing, but police dismissed that theory too quickly. If the defense could establish a nexus between the crime scene and the potential Odinist suspects, it would strengthen their argument that Richard Allen was not the perpetrator. Nexus problem. The court has ruled that the defense does not provide a direct nexus, between known Odinist and the actual crime scene. Without clear evidence such as DNA, witness statements, or confessions, the argument remains speculative in the court's view. Alleged investigative bias and tunnel vision. The defense claims law enforcement focused on Allen while ignoring leads on other suspects. They argue that investigators failed to properly follow up on evidence that could connect other people. The prosecution contends that there is no verified evidence tying any alternative suspect to the crime scene in a way that would justify shifting focus away from Allen. The judge has agreed, limiting the defense's ability to introduce these third-party theories. No, they couldn't. Have a good night. Let's see. I think the defense found Michael Jackson missing glove at the crime scene. That's not Gull law. That's Indiana state. If no nexus, third party not allowed. No, you heard it. All of this comes from Indiana law. Oh, none of those. Okay, I see what you're saying. The trial was Indiana versus Richard Allen, not Ron Logan. Yes, none of those were there. Gull followed the law. Okay, I understand, and yes, I agree with that statement. The prosecution knew about the nexus between Keegan Kline and Ron Logan. Boom. Where is the evidence that puts Keegan Kline at the crime scene at the time the murders happened? Maybe we'll find out. All right. Talked about depositions. Okay, here we go. Additionally, the defense could have asked the Department of Corrections to provide video from the very pod where Ricci Davis and Keegan Kline were housed to determine whether Kline and Davis were frequently talking with another. As Kline has apparently stated in State's Exhibit 4, that Kline has only talked to Davis maybe 2 times. If the video shows that Davis and Kline talked to each other well beyond 2 times, then it could be determined that Kline was lying. Whereas if the video shows that Davis only talked to Kline 2 times, then it would show that Davis was lying. Either way, the defense had a right to those letters to conduct its own investigation concerning the veracity of the contents of those letters. McClelland's claim that he did not turn over the Davis letters because he, McClelland, made his own determination that the letters were not in fact exculpatory denied Allen and his attorneys the opportunity to conduct its own investigation from the information contained in those letters and determine what to do, if anything, concerning the contents of those letters. So, what I believe should happen now, and this is just my opinion, my belief, because the defense is now coming out about these letters and everything, a hearing should be done. Both sides should be able to present all of their evidence, and the judge should make a determination. Not just blankly deny everything. That's how our other trials are run. But not this one. And why is that? Because I don't think Judge Gull wanted this case. In his February 28, 2025 response, McClelland makes much noise about Attorney Baldwin attempting to put into the public domain information through the filing before verifying that information. It should be noted that Attorney Baldwin first attempted to work the matter out with McClelland via email before filing his motion. On February 12, 2025, Baldwin had emailed McClelland asking for the Ricci Davis letters. On February 13, 2025, at 2:41 p.m., McClelland responded as follows. The information that we have concerning Ricci Davis was forwarded to you as part of discovery. You had every opportunity to call Mr. Davis at trial or at the hearing on third-party motive. You chose not to. Your strategy was not to call those people. The trial is now over. Richard Allen was convicted. If you feel you need to file additional motions, then file them. The state will respond appropriately. The state will follow any orders the court puts out in regards to those motions. Emphasis added. Before filing any motions, Attorney Baldwin made one more attempt to simply obtain the letters. The defense responded at 3:54 p.m. on February 13, 2025, by asking McClelland whether he was admitting or denying that he, McClelland, had received letters from Ricci Davis in the months leading up to the 2024 trial. McClelland could have quickly answered the question and then provided the letters to the defense and perhaps avoided any more filings. McClelland could have also asked Baldwin to hold off on filing anything while he, McClelland, gathered the letters to turn them over to the defense. Instead, McClelland chose to ignore the defense's request, prompting the defense to file its February 14, 2025 motion to preserve and produce the Ricci Davis letter. It should be noted that the defense was seemingly up against a deadline of sorts. If the defense waited to file their motion, the judge might rule on the motion to correct errors beforehand, which arguably would prevent the defense the ability to file the motion to preserve and produce, as such a ruling would arguably kick the case to the appellate lawyers. Well, you know what? I think it's time for the appellate lawyers to take over. I really do. Also note that in his February 13th email response, McClellan claimed to have provided the defense all the Ricci Davis letters. During discovery, this was simply an untrue and misleading statement typed on his computer and sent to the defense by McClellan. Through his February 28, 2025 filing, this court learned that McClellan actually was in possession of these letters on February 13th, 2025, which contradicted McClellan's representation to the defense that everything had been turned over. Why would the prosecution continue to provide the defense team with information it received after the trial was done? It wouldn't. Now, if information was received from the defense that these things occurred, this is information that the defense team should be giving to the appellate lawyers for Richard Allen so that they can put that in their appeal. And the appellate lawyers would be requesting this information from Nick, not Baldwin. Oh, absolutely. No, they have not filed the appeal yet because we're still dealing with all of this BS from Baldwin. Baldwin needs to step back and let the appellate attorneys do what they need to do. Okay, I'll take a look at it after this, Holly. Yeah, that is kind of interesting, isn't it? Yes, all of these filings are related to the appeal. Should not be going through Baldwin. It should be going through the appellate lawyers so that the appellate lawyers can then request this information and put it in their appeal information. Baldwin lost the case. He needs to back off, and he needs to let Richard Allen's appeal lawyers take precedence of this case. Yeah, he is trying to save face, but he needs to step back. His job is done. All right. Also note that in his February 13th email response, McClellan claimed to have provided the defense all the Ricci Davis letters during discovery. This was simply an untrue and misleading statement typed on his computer and sent to defense by McClellan. Through his February 28, 2025 filing, the court learned that McClellan actually was in possession of these letters on February 13th, 2025. So once again, the trial is over. Nick McClellan doesn't owe anything to the defense once the trial is over. McClellan chose to intentionally mislead defense counsel about McClellan's possession of those letters. McClellan was getting called out by the defense once again, and once again he was ultimately forced to turn over the letters, perhaps out of fear that the defense would eventually gather DOC records that would then expose McClellan's misrepresentation. I just don't get it. I don't think Baldwin gets it. His client was found guilty. He was sentenced. This information was provided after that guilty verdict. It's over. The prosecution doesn't have to give Baldwin any more information. Once again, is referring to the other times that McClellan was forced to turn over items after being called out by the defense, as detailed in the next section of this memo. Allen and the defense team are not conceding that the DOC records that McClellan admitted as exhibits are proof positive that other letters don't exist. The defense has no idea how records are kept or how accurate those records might be. The defense also is not sure how McClellan was so quickly able to access those records from Newcastle. Certainly, as detailed above, McClellan's response to the motion to correct errors, in which McClellan provides details found nowhere in the Ricci Davis letters, provides a compelling argument for the belief that either other letters exist or video exists that has not been turned over. Are the letters McClellan finally provided to the defense truly the only letters and or videos in his possession? McClellan recently responds to the defense motion to correct errors, provides troubling statements that cast doubt on McClellan's claim that these are the only letters or evidence that are in the prosecutor's possession. In the prosecution's response to the defense motion to correct errors, in an apparent attempt to discredit Ricci Davis, McClellan claims that McClellan, had information that Ricci Davis had claimed that Ron Logan took batteries out of Libby's phone. This is curious because the prosecution has failed to produce any document or videotape in which Ricci Davis makes such a claim. The defense has found nothing. This leads to serious question of where did McClellan learn of this information. The defense is left with one of two possibilities. McClellan has additional Ricci Davis letters, reports, or video from where McClellan, gained that information, or two, for reasons that are unknown, McClellan made up the story. It seems unlikely that such a specific story would be made up, leaving the defense to conclude that McClellan has additional Ricci Davis letters, reports, or video, but has not turned it over to the defense. What if this information had nothing to do with Ricci Davis and that it was given by other people during the investigation of Ron Logan? What if it was a rumor that had been heard? Baldwin cannot specifically state that this is from the Ricci letters, because it may not have been. It may have been. It may not have been. We don't know. McClellan has not explained to this court, nor anyone else, from where McClellan claims he learned this information about the batteries. Nor did McClellan back up his story about the batteries with an exhibit attached to the filing. Also note in that email that McClellan requested Attorney Baldwin to file something, which Baldwin did, only to have McClellan then cast aspirations about the filing. McClellan's history of holding on to exculpatory evidence until being forced or called out by the defense. Unfortunately, as has been the historical pattern of the prosecution, McClellan made the decision to hold on to those letters until called out by the defense, much like he made the decision to hold on to other exculpatory evidence over the course of this case. Again, Indiana courts of appeals have commented on patterns of withholding exculpatory evidence and have even reversed convictions when prosecutors have exhibited such patterns. Well, that's fine. But then this needs to go to the upper court so that they can do that. It's not going to do that if you keep filing these things and don't let the appellate attorneys take over. Steve Mullins claimed that the Brad Holder and Patrick Westphal and other crucial early interviews between 2/14/17 and 2/20/17 were recorded over was not relayed to the defense until 1/30/2024, in spite of the defense asking for that evidence since August 10, 2023. As anyone in the criminal justice system knows, most of the most important interviews are those interviewed closest in time to the crime. Brad Holder and Patrick Westphal were on law enforcement's radar screen as suspects very early on in the case, a fact that is evidence from reviewing emails all the way up the chain to Doug Carter in the early days of the investigation. Those emails were admitted as evidence during the July 30th, August 1st, 2024 hearings. Because of law enforcement's very early interest in Brad Holder and Patrick Westphal, each were quickly found and then quickly interviewed on February 17, 2017, within 3 days of the murders. On August 10, 2023, the defense first unveiled to the prosecution that the defense, believed that the state's own evidence supported that Holder and Westphal were involved in the murders. From a single 2-part page document found among hundreds of thousands of documents, the defense found evidence, there's that word again, evidence, that law enforcement had interviewed Holder and Westphal on February 17, 2017. It's not evidence, it's a fact. There was an interview. And that both interviews were memorialized through audio videotape. It was after the August 10, 2023 deposition of Jerry Holman that the defense began demanding those interviews, which the prosecution should have already provided to the defense. When McClellan and Mullen failed to turn over those interviews or explain what had happened to those interviews, the defense called out the prosecution in the Franks memo filed on September 18, 2023. Footnote 66 on page 56 of the memorandum details that the prosecution had failed to turn over the Holder and Westphal interviews that the defense has been seeking, even after the Franks memo was filed and the defense alerted the court, calling out the prosecution for not turning over the Holder and Westphal interviews. The prosecution still refused to answer the very simple question posed by the defense of, where is the Holder and Westphal videos? Please turn them over. The defense heard crickets. Instead of immediately alerting the defense on August 10, 2023, that those videos had been taped over, McClellan and Mullen said nothing. Finally, on January 30th, 2024, the prosecution provided a document that detailed some of the contents of certain hard drives that had turned over to the defense. In the fine print on page 5 of this document, the defense finally learned that McClellan and Mullins were claiming happened to those crucial interviews. They were recorded over. So, in my opinion, the prosecution was wrong in this. They should have come out right away and said, we can't find them. We're looking for them. or, we're combing through everything we have. And then as soon as they found out that those interviews were not recorded, that they didn't have the recordings, they should have told the defense. They should not have been dragging this out. And that's on the prosecution and the police. They just didn't want to look bad. When in reality, if they would have just came out and said it right away instead of trying to hide it, it wouldn't have been as big of a deal. All right, so they were recorded over along with all other crucial interviews between 2/14/17 and 2/20/17. Neither McClellan nor Mullins called the defense and said, "We should have just told you this when you first got on the case, or at least back in August 2023. But those interviews you have been seeking for the last 5 months were taped over in 2017. Exactly. Should have just told them straight up. Defense counsel has practiced for over 30 years. During that time, if the prosecution in any other county ever received exculpatory evidence or learned that certain evidence had been destroyed, it would immediately contact the defense and tell them on the phone or in person that the evidence had been destroyed. In this case, the defense was lucky to even notice Mullen and McClellan's claim that the crucial video had been taped over, as such information was sandwiched between other minuet contained in the document. Now listen, I get that in today's technology and today's world, there should be video and reports about everything. Okay? That's today in 2025. And that's because of the things that we've learned throughout the years. But we know the Delphi murders case is not the only case that has had issues with videos or things being taped over, things like that. It happens more frequently than we realize. Should it? Not today, it shouldn't. But back then, I don't know. Well, I don't know. I don't know what they were using before they got this new technology. I think they were just writing reports. When was the new technology provided to them? What year? Were they still working out kinks and learning how to use it? Those are questions that people have to ask and should be asking because it matters. Now, if they had had it for years and this was happening, then that's a big issue. But if this was a fairly recent transaction of doing it the old way versus the new way, and they were still working out the bugs and everything, then I can understand how it could happen. But not today. Back then, maybe, but not today. This should also not be overlooked if, in fact, those crucial videotaped interviews were actually taped over. That would be colossal news that Mullins and McClellan would not have forgotten. I agree with that. Losing such evidence would be the talk of the Unified Command due to the serious nature and potential serious consequences of losing such important evidence. Now, here's my thing. If you didn't have the videotaped confession or interview and any reports that were done by the individuals doing the interview, that would be huge. That would be huge. But you had reports. To lose such crucial evidence early on in the case would not be the type of thing that would ever leave the memory of the man in charge of that evidence, Steve Mullins, nor the minds of those in unified command. Therefore, when the defense requested the prosecution to turn over those interviews, Mullen and McClellan should have immediately said to themselves, "Oh no, those interviews were erased back in 2017. I need to immediately tell the defense. I should have told them that when they got on the case, but I will do it now. It is inexcusable that Mullins and McClellan would not have remembered in August 2023, when the defense first requested those interviews, that those interviews had purportedly been recorded over. Yet neither McClellan nor Mullen told the defense of this earth-shattering type of news that Mullen had known for 6 years at that time." Well, let me tell you what. When you have as much as you had coming in on this case, you're not going to remember all those details until you look back at things. So it is possible that they put that out of their mind. I'm just saying, the defense is all matter of fact here, but I'm not saying it happened that way. But I am saying that it is possible that they didn't think about that until they were forced to look it up. But I also agree that the defense should have been told immediately once they knew the recordings were recorded over. Surely a report existed that would explain the terrible accident that caused crucial evidence to be forever lost. However, no such report had yet been tendered for the defense. Is it in their procedures to write up a report that says how these interviews went missing? Probably not in these small rural areas. Sorry. Should it be now that it's pointed out? Should it become a procedure? Absolutely. Some point in time later, the defense finally received such a report. It was drafted by Steve Mullins. Inexplicably, it was undated. Therefore, no one knows if the report was drafted in 2017 or sometime in 2024 or anywhere in between. That document was entered as an exhibit at the March 18th, 2024 motion to dismiss. This undated document is not normal, nor the normal way that the law enforcement and prosecution operates. All right. Let's see what everybody's saying here. Where did I leave off? Baldwin failed to mention Ari mentioned in letters as killer. Nobody's a class clown. We're just throwing things out there. The evidence, Ricci letters that he wrote to McClelland. Richard, that is something Keegan Klein told Ricci during the trial. Prior to that, he never said who the third person was. The letters Ricci sent to McClelland included Allen and did not exclude him. Baldwin lied. I believe the LE tried very hard in those years to find connection to all those other men, and they couldn't find anything. They could not use. But as soon as RA came up, he was bridge guy. And that's because he put himself at the crime scene. Lynette, I do not believe that the appeal has been filed yet. Okay. All right, saw that one. Maybe they're giving Judge Gall the opportunity to do what's right. She can also order a new trial. She's done. She's going to let the Supreme Court take care of this. She's going to continue to deny everything that the defense brings forward and let the appeals take care of it. And yes, by doing this, they keep moving out the date that they have to file the appeal by. Once again, if he got it after the trial was over, doesn't matter what he got. He doesn't have to turn it over to the defense. All right. This must be, I'm no lawyer either, but it's just common sense. Why not have the hearings? Why not have a hearing on the motions and the memorandums and all of that? Let both sides hash it out in front of the judge. Sorry about that, mouth was getting dry. Let them hash it out and have the judge make a decision. And here's my thing. Judge Gull said that her schedule was so full, then she should have told whoever requested her to be the special judge on this case that she would not be able to hold all the hearings on the motions and memorandums as soon as they appointed her judge. If that's the reason she's not doing this, she should have told them so that they could pick a different judge. It does with the defense team. All right. If a trial is over and the defendant has been convicted and a prosecutor receives additional information, do they need to hand it over to the defense team as discovery? What in the heck? Okay, response 1. Yes, even after trial has ended and the defendant has been convicted, a prosecutor still has the duty to disclose new exculpatory evidence to the defense. The obligation is based on Brady versus Maryland and extends beyond trial, especially if the information could affect the fairness of the conviction or sentencing. If the newly discovered evidence is material, meaning it could have impacted the verdict, it may provide grounds for an appeal, post-conviction, relief, or even a new trial. Defense attorneys can file motions based on this evidence, arguing that it supports a wrongfully convicted claim or demonstrates misconduct by the prosecution. This concept ties into cases like the Delphi murder case, where the defense has challenged the investigation's focus and whether alternative evidence was fully explored. If new evidence first surfaced that cast doubt on Richard Allen's guilt, prosecutors would be required to disclose it, and it could become a key factor in post-conviction proceedings. Okay. Yes, even after a trial is over and the defendant has been convicted, a prosecutor is still required to disclose exculpatory evidence to the defense under the Brady rule. So once again, this goes on whether it's exculpatory or not. And who is it up to determine whether it's exculpatory? Well, we read through that in the beginning when I started, and it's up to the prosecutor to determine if it's, I forgot the word, exculpatory or not. This includes evidence that could show actual innocence or the witness testimony evidence used in trial was unreliable. So it says prosecutors have an ongoing ethical duty under Rule 3B 3.8 of the ABA Model Rules of Professional Conduct to disclose any credible evidence that suggests a wrongful conviction. Some states have specific laws requiring post-conviction disclosure, and courts have ruled that failing to disclose new exculpatory evidence could be grounds for an appeal, a new trial, or even a reversal of conviction. If the withheld evidence is material, meaning it could have affected the trial outcome, the defense can file a Brady violation claim. If the court agrees, the conviction could be overturned or require a new trial. So, okay, all of it needs to be turned over, even after conviction. I'm sorry, I was wrong on that. And then, instead of filing these motions to the judge, according to this, the defense should just come out if they feel this information was exculpatory and the prosecution felt it was not exculpatory, they should file a Brady violation claim. Okay, a Brady violation claim where the prosecution is accused of withholding exculpatory evidence can be handled by different legal authorities depending on the stage of the case. Trial court, post-conviction motions. If the Brady violation is discovered before or soon after conviction, the defense can file a motion for a new trial or a motion to vacate the conviction in the same court where the trial was held. The judge will review whether the withheld evidence was material, meaning it could have affected the trial outcome. Appellate court, direct appeal. If the defendant is already convicted and has exhausted trial-level remedies, they can appeal to a state or federal appellate court. The appeals court will determine whether the withheld evidence was significant enough to warrant overturning the conviction. Post-conviction relief courts. In many states, including Indiana, defendants can file post-conviction relief petition under the state law. PCR petitions argue constitutional violations, including Brady violations, ineffective assistance of counsel, and new evidence. Federal habeas corpus if state remedies fail. If state courts deny relief, a defendant can file a federal habeas corpus petition under 28 U.S.C. for state convictions. A federal judge will review whether the Brady violation has a due process violation that justifies overturning the conviction. If the prosecutor intentionally withheld evidence, the defense can file a complaint with the State Bar Association. This could lead to disciplinary action against the prosecutor, including sanctions or disbarments. Possible outcomes of a Brady violation claim: new trial. If the withheld evidence was crucial to the defense, conviction overturned. If the violation is severe, sentence modification. If the evidence impacts sentencing but not guilt, no relief. If the court finds the evidence wouldn't have changed the outcome. So maybe the defense team should take these other steps instead of continuing to put this in front of Gull, because they know that Gull is just going to deny whatever they're asking. So get others involved so that you can get to the appeals process. Not if he didn't consider it exculpatory, is what I'm reading. Not necessarily. They have to prove that it would change the outcome of the trial. Maybe he did. And if he did, he should be punished. I don't know. I gotta go and look when he met with them. Well, if they hid those letters, then they all should get in trouble. Nick said that there wasn't a video, and that yes, there was a letter that was missing that he doesn't know where it went. Hi, Queen. There was a lot of info about Ron Logan before, during the trial. Remember his girlfriend? Yep. Between this case and the Idaho 4, there are too many lies. You might as well throw in there the Karen Reed trial too. Because that one is just as messed up. If it wasn't in the Ricci letters, that just means Nick didn't hand the police report info to the defense, or he lied in his filing, which he didn't sign as true under penalty. Okay. Yeah. I would love to know if he did, because then we should have somehow be able to get all of them. It sure slows it down. I mean, we all know that the appeals court, it's going to take a while before they even look at this. So why not just file the appeal right away? And then if you have to amend it because you get more information, do that to get things rolling. He should have sent his letters to the defense. What? How cocaine can he be? They're all probably jacked up. I know, we're all just speculating at this point. Oh, good God, am I behind? Who's TJ? Probably you, just abbreviated for trial junkie, but I don't know for sure. I'm just assuming. They could be. But I'm pretty sure there's enough proof now of her doing that. With all of the motions and memorandums and everything that they filed, that she has just outright denied with no explanation, I'm pretty sure they have that. I'm just a lady who watches trials. No, I get it. And like I said, if he did things wrong, he should pay for it. Who knows? It is. This is the worst part. It's not only a disgrace to those girls, it's a disgrace to their families that they have to continue going through this. No, I get that people are upset about the verdict. All I'm saying is this, being somebody who was in that courtroom day after day after day watching this stuff, okay? The jury made the right decision based off of what they saw and heard. Okay? Now, should the third party information come in? Should the oldness come in? Should this and that have come in? Maybe. But that's why I'm saying it's up to the Supreme Court to say, go, you were wrong. You should have held a motion and a hearing on this. This is information that should have went forward to the jury. Hold her accountable or back her up and say she was right in what she decided. That's what bothers me the most, is that during this trial, these two girls were forgotten about. They really were during a lot of it. And that is what bothers me. They think we're all dumb. Right, but you have both sides saying that it's not exculpatory, and then you have the other side saying it is. So who determines who's right? Because Judge Gull's not going to do it. I agree. FBI started using Orion in 2008. They had Orion, yeah. $2008. This, yeah. No, I'm not saying that. I'm saying who's the middle person that's going to decide if it's exculpatory or not. Because prosecution is saying no, it's not. Defense is saying yes, it is. Judge Gull isn't doing a damn thing about any of it. So who's going to stand up and make the decision? Alarms are going off. Might be. Let's see, we had the onus. Yep. Then the confessions were tortured out of RA. Then it was Brad Weber. Now Ron Logan, Keegan Klein, and according to Ricci, Allen also. Which is it? After the fact. I don't know. Well, after what I just read, you're right. He does. He's got to turn it over. It's all legal maneuvering. It really is. Yeah, but they should be able to amend that if additional information comes in that they didn't have when they first filed the appeal. There should be an amendment to the appeal stating, hey, we just received this information. We want to add it into our appeal. If they allow evidence in without Nexus, they will be breaking India. Maybe. Yeah. Is that what he said? All right. So is it a... Your guess is good as mine. If I were if I were Andrew Baldwin, I would file a Brady violation. I wouldn't screw around with Gull anymore because you know she's going to deny all of his motions. File it. It's post-conviction. It could be looked at by somebody else now. And let's go from there. Right. If it's not exculpatory, they're not required to turn it over. But at this point, now it's being refuted, I guess, as it is exculpatory. So now who makes the decision? When a judge doesn't want to do her job and just doesn't want to deal with it anymore, who makes the decision? That's my question. I'd be filing a Brady motion, absolutely. I'm laughing. I thought you were quacking. Just because he says so doesn't mean it is so. So who makes the determination? Maybe. I will agree with you on that. Yeah, but how much do you get into the record, really? She's not holding hearings. She's not. So unless they go out there and they put in 150 pages of what they need to truly prove that what they're saying is true, how does that help? Not enough is being put on the record to help them. That's what I'm saying. The only thing the Supreme Court said she was wrong before, Andrea, is that she did not follow the correct steps when trying to remove the attorneys. There was additional steps that she should have taken before just removing them. That's all they said. And that's when they put the attorneys back on the case. Not that she was wrong in all this other stuff. That's why we need them to hear the appeal, to tell us what else she did wrong. Good. Go already looks bad. Oh my gosh. Bellingham. This is a lifesaver. I urge you guys to go out and use Copilot, ChatGPT, or Gemini for Apple. It's a lifesaver. I use it on everything now, not just my YouTube stuff. Any kind of question about insurance or anything, I pull up one of them and use it. I don't know. Yeah. Because she didn't follow the proper steps. Just like she has not followed the proper steps throughout this whole thing. She has not held hearings like she should on motions and memorandums and everything else. She's doing things her way and not the proper way, and that is what's going to get her in trouble. Be nice. We can all agree to disagree on things, but be nice about it, okay? That's all I'm asking. All right, everybody. Where am I? We're going to have a part 2 because I still, if we even need to, I don't know if you guys need to hear the rest of the pages. You let me know. But we're on page 16 of 24. So if you want to hear the rest, let me know in the comments below here. And what is tomorrow? My days are all mixed up this week. Tomorrow's Friday. So if I go over the remaining pages, it's going to have to be tomorrow afternoon. Because I want to watch the Dateline episode between Keith Morrison and Lori Vallow Daybell tomorrow night. That I've got to hear. That'll be interesting as hell. So, so far I only got one person saying yes, do part 2. All right. Another one that says yes. Okay. I will do this tomorrow afternoon. I'm Central Time, so I always have to say my time and your guys' time. Because a lot of you are Eastern. Let's say 2 p.m. my time, 3 p.m. Eastern time. I will set up a live here in just a little bit for that. And that way in the morning, oh my gosh, my poor pen. Dumb pen. Oh, there we go. 2 p.m. Okay. That way in the morning, I can do some pre-recording of chapter 6 for What Happened to Tabby also and try to get that out this weekend. So, 2 p.m. my time, 3 p.m. Eastern time. We'll be back. We'll go over the rest of this. I'll look up anything that we need to. Now that you guys know this is how I do this, if at any time I'm reading this stuff and you don't understand anything, you can throw a question in the chat and I'll look it up. But I really urge you guys to start using this stuff with your questions, even in your everyday life. It can do so many things for you and help reduce the amount of time you spend on research. Looking forward to seeing you again. Thank you. Gold tried to strong arm the defense. I have nothing good to say about Gold. She tried to ruin my life for a month and did a pretty good job of it. So, all right. I will see you guys tomorrow. What do I always say at the end? Remember, justice matters for the victims and for their families. And let's finally get these cases right and going in the right direction, because all this chaos with all these cases is driving me crazy. All right, everybody. Have a good night, and I'll see you soon. Bye.